legal insights and puts into context legal concepts in order to answer your questions, views, and reviews. In order to answer your questions, views, and reviews. Can we do it again? Live on Twitter, we're live on Instagram and YouTube. On Twitter, now X, KUTV_Kenya. On Instagram at KUTV Kenya, YouTube KUTV Kenya. Now, there comes a time when something must come to an end. There comes a time when employment must come to an end. In tonight's discussion, we delve into this topic with a razor-sharp focus on the legal provisions and safeguards when it comes to dealing with matters termination of employment. My name is Elvin Onsongo, and before we delve deeper into this discussion, I will let my guest to introduce himself.
Thank you, Onsongo. Thank you for this opportunity. I'm happy to be here. My name is Otto Nduva. I am an advocate of the High Court of Kenya, currently working at Nduva Kitonga and Company Advocates. We are here today to demystify the concerns regarding employment law while focusing on termination and dismissal. And I look forward to having this conversation with you.
Counsel Otto, thank you very much for coming to Law Matters. And without further much waste of time, take us through some of the legal legislations which we expect that you're going to mention in our discussion tonight.
Okay. So, Onsongo, as you stated, employment has to come to an end at one time. And our country, Kenya, we have laws and statutes governing employment law. And first, we have the Constitution of Kenya. And the Constitution of Kenya under Article 41 provides for labor relations. And the said article provides for the rights of employees and it provides for the rights of employers. So the employees have several rights. They have a right to fair remuneration. They have a right to reasonable working conditions. They have the right to join trade unions and participate in the activities of trade unions. And they have the right to go on a strike. The employers, on the other hand, they also have their rights. They have the right to join employee organizations. And they also have the right to participate in the activities of the organization. Additionally, we also have Article 162 of the Constitution. So Article 162 of the Constitution, it establishes the Employment and Labor Relations Court. So this is the court that is tasked with dealing with disputes between an employer and an employee. Other than that, we go to the next statute, which is the Employment Act. So the Employment Act under Part 6 talks about termination and dismissal, and this is what we are going to majorly focus on. And after that, we also have the Employment and Labor Relations Court Act. So this act is what gives the Employment and Labor Relations Court its jurisdiction to hear and determine matters employment.
Thank you, Counsel Otto. Now we're talking matters employment. Tell us, when does employment start? Where does it begin? And why is it important to mark the beginning of a contract of employment?
So most of the time when a dispute has been taken before court will, in as much as the courts will try to look at when the employment ended, it will also look at when the employment began, because the beginning is very important. The beginning is important because it establishes the rights of the employer and establishes the right to the employee. And if you look at Section 2 of the Employment Act, it defines a contract of service as an agreement, whether oral or written, whether implied or expressed, to employ or to work as an employee for a period of time. So the court will look at, is there a contract of service in place? So the contract of service is what marks the beginning of an employment.
Thank you. And take us through the understanding of a termination notice and how it is essential within contracts of employment.
Okay. So before we look at the termination notice, I am going to give you a hypothetical scenario so that we can bring this discussion closer home. So we have an employee. The employee goes by the name Ken. and the employee works in a chocolate factory. So if you look at Section 35 of the Employment Act, it provides for the termination notice. So for example, if Ken, the employee, is working in the chocolate factory and is paid on a daily basis, so when the termination notice is given out, it can be given out at the end of the day without notice. If Ken receives his wages periodically, let's say for a period of 2 weeks, for the contract to be terminated, he has to be given a notice of 2 weeks, and the notice has to be in writing. If Ken is working and he's paid his remuneration at intervals of 1 month, he has to be given 1 month's prior notice to the termination of the contract of service. Additionally, Ken and the chocolate factory, they might have a contract that stipulates otherwise. They can say that for the contract of service to be terminated, you have to give 3 months notice. So the employer has to comply with that before issuing the termination notice.
Very good. And now that you've made us understand properly the meaning and the concept of termination notice, what are some of the effects of failure to issue a termination notice by an employer to an employee?
Okay. So the failure to issue the termination notice by the employer will amount to unfair termination. And unfair termination is something that's covered for under Section 45 of the Employment Act. And for termination to be fair, there are there are three things that have to be considered. Is the termination valid? Is there a reason for the termination? And was due process followed when terminating the services of the employee?
Thank you. We've had cases where employers have had operational or structural changes within their work environments, and they result into dismissing employees for their roles becoming futile or unwanted within such working environments. In the legal spectrum, I believe you call this redundancy. Now, take us to the understanding of what redundancy is and how it is governed by the law.
Okay. So redundancy is when an employee loses his employment by reasons which are not his or her fault. So we have Ken here, for instance, and it's the chocolate company. So the chocolate company is facing stiff competition from the competitors. The chocolate company cannot keep up with the emerging technological trends involved in the production of chocolates. And the chocolate company is undergoing a lot of financial strains. So you find that the chocolate company cannot be able to keep on remunerating Ken for the work that he's doing. So for that, it's provided for under Section 40 of the Employment Act on the redundancy. And there are various steps that have to be followed before you can terminate an employee on account of redundancy. One, the employer, when doing this, should not do this out of spite or out of malice. There has to be a reason, and a valid reason. So we have Ken here. So Ken is a member of a registered trade union. So for the employer to terminate Ken's contract on grounds of redundancy, the employer has to give a 1 month's notice to the trade union which Ken belongs to and to the labor officer. That is very important. But then what happens if Ken is not a member of a trade union? So the notice has to be given to Ken personally, and the notice has to be explained in a manner in which Ken will understand. Additionally, let's say the company has several employees. So the reasons for kicking off Ken and letting some stay, they have to be fair, and they have to be employed equally among all the employees. And the Court of Appeal recently made a decision, and you find that employers, they would employ this tactic: last in, first out. This means that if you're the last to join an organization, when redundancy kicks in, you'll be the first to be kicked out. But then that's not the case. So the court acknowledged that the new employee might come in with fresh knowledge, with fresh skills, which might be beneficial to kick out the employee.
One of our viewers is asking a question: what do you mean by a chocolate company?
bread company, it's a hypothetical case. Their bread company to be a company for making iron sheets. It's a hypothetical case to bring this discussion closer. Yes.
Now, among the grounds of Kenya is misconduct by an employee. What
Employer does not have the right to dismiss an employee without giving valid notice. It does not entitle an employer to do that. What should happen is that fair procedure has to be followed, and the procedure is that the notice has to be given to the employee. The notice has to be in a language in which the employee understands, and if the employee does not the language contained in that written, the employer has to explain it to the employee in a language that the employee will understand. Additionally, the employer has to give the reasons that amount to misconduct so that he can have a chance to defend himself. Importantly, the employee has the right to come on board with a fellow co-worker or a member of the trade union during the hearing.
Thank you, Council Otto. We've also had concept of contracts where an employer intends to assess the suitability of an employee before they confirm them for full employment. I believe these probationary contracts. Now take us through the journey of understanding probationary contracts, how they work, how long they exist, and how they are governed by the laws in Kenya.
So, as you've said, probationary contracts are provided for by the Employment Act, specifically under Section 42. And this is a way of the employer assessing the employee. Is he fit to remain in my organization? Does he have the necessary skills? Is he working hard enough to give me the profits that I want? So for a probationary contract, Section 2 of the Employment Act provides that such a contract should not be more than 12 provides that no notice has to be given to the employee on a probationary contract and terminating the contract. So there have been two schools of thoughts about this. There are courts that say, yes, this is what the law provides, so no notice is sufficient, and the employee should not be accorded a hearing. However, there are also courts which have been saying that that's not right. Employees have to be accorded a fair hearing. So to settle this dispute, there was a three-judge bench that was constituted to determine the constitutionality of Section 42(1). And what the court came to say is that even for employees on probation, when you want to terminate their contract, you have to give them valid notice. You have to accord them a hearing and give reasons as to why they are opposing the intended termination. So yes.
So in essence, what counsel you're telling us is that even an employee who is under a probationary contract enjoys the same safeguards as any other employee under the safeguards provided for under the Constitution and the Employment Act.
Being an employee under probation does not mean that the principles of Article 41 of the Constitution do not apply to you. So yes, they apply to you and you're entitled to those rights.
Thank you, Council, for that digest. We've seen cases where employees have gone to court suing employers for improper or what you call unfair termination based on unfair grounds. Now, does an employer need to prove the grounds for termination during such cases in courts?
So it is important to note that when your termination is going to be, when you're an employer and you want to terminate the services of an employee, you have to ensure that you've given the reasons for the intended termination. And those reasons have to be given at the initial stage. So for example, Ken is working at a chocolate factory. And I have more to add.
Give us more examples.
So it is important to note that during the disciplinary hearing, if Ken, for example, admits that he stole the chocolate, so the employer is has every right to terminate his employment even without according him a hearing due to his own admission. So yes, that's it.
We've also, Council, seen situations where an employer may dismiss an employee without notice or by giving less notice as required under the contract or under the law, and this is what you refer to as summary dismissal. Now, take us through the understanding of what that concept entails and how it is governed by our laws.
Okay, so summary dismissal is provided for under Section 44 of the Employment Act. And like you've said, it's when an employer terminates the services of an employee with less notice than provided for or than required as provided for by the contract or by statute. So there are several reasons why an employer can decide to summarily dismiss an employee. So the first reason is the employee goes for an extended leave without attending work with no sufficient lawful reason or cause. So for example, Ken fails to show up to work for a period of 10 days. The employer can summarily dismiss him. But before he does that, the employer has to demonstrate that he or she has put in efforts to trace Ken, for Ken to come to work so that he can be given the notice of termination. The other reason for summary dismissal is on grounds of intoxication that will render the employee incapable of performing his or her duties. So for example, it's on a lunch break. Ken has gone out for his lunch around 1. Then he comes back to work around 2:30. He's clearly drunk. And you see, the employer will tell Ken that you are drunk, and Ken will dispute it by saying, I'm not drunk. So what the courts have said is that when such a scenario, to prevent my word against this, the employer has to ensure that at least a scientific test has been done upon Ken to make sure that he's intoxicated. Also, summarily dismissing somebody as a result of intoxication, it ought to be as a result that the employee cannot normally perform the work that he does. So it's two things that go hand in hand: intoxication and inability to perform what normally you should do. Additionally, there are instances, for example, Ken might be out and then he's arrested for a cognizable offense. So this is an offense where you are arrested without a warrant. So he has been detained for more than 14 days. So you are in custody for more than 14 days. You have not shown up. You've not shown for work. The employer can summarily dismiss you. Additionally, if an employee uses abusive language at work, summarily he can be summarily dismissed. Lastly, it's also on issues of theft, like I said. If the employer has reasons to believe and has proof that the employee is stealing from him or her, he or she can summarily dismiss the employee.
Thank you, Council Otto. I believe Ken is a hypothetical friend and not a real friend. On that note, we take a summary break. The Law Matters will be right back. extricate himself out of the accusation and come back to sue the company.
Okay, I understand your question. Thank you. So what you have to understand, it's on procedure. As an employer, you found or you have reason to suspect that Ken is stealing from you. Do not rush. Take take deep breaths if you have to. Remain calm. Because if you don't and you harshly or out of emotions you tell Ken, go home, don't come back, it's going to hurt you. It's going to cost even more than it could have had you followed the due procedure. So we have our employee here, Ken, is stolen. As an employer, what should you do? You should first issue a notice of termination to Ken. And importantly, it should contain the reasons for the termination, and in this case, it's theft. If Ken, for example, does not understand the contents of the letter, for example, if it has been written in English and Ken only understands Kiswahili, the employer has a duty to explain it to Ken in a language that he will understand, and this language will be Kiswahili. So after that, Ken has been given the notice of termination of his employment. So what happens next? So Ken has the right to respond to the contents of the notice of termination. And importantly, when the employer is giving the notice of termination, all sufficient documents backing up his reason for termination ought to be attached. So, for example, Ken had a habit of stealing, so this was not his first time. So, were there warning letters that had been previously issued to Ken? So, those have to be attached to support the employer's claim. Do you have the evidence? Do you have a catalog? Do you have CCTV footage? Do you have eyewitnesses? All those accounts should be part of the reasons for given by the employer when he's compiling his or her conduct of the employee during his or her term of employment. The court will also look at whether or not if the termination was came to an end, was the employee given his dues? Because you find that one mistake that's also made is that when, as an employee, you're fired, the employee does not give you your dues. He does not give you the money that is owed. So, for example, you've been summarily dismissed and you've not been given your 1 month payment in lieu of notice. Or, for example, if the contract stipulated that a 3 months notice has to be provided, the employer has not given you 3 months worth of salary. So these are the things that the court will look into so that they can ensure that justice is served.
Okay. Counsel, you have mentioned to us that an employee is at liberty to challenge or to mount an appeal against a decision of the employer during fair trial. Now, what is the possible outcome on such or upon such appeals to the court? Can a court of law overturn the decision of an employer made during the fair hearings?
So it is for this reason that we have specialized courts to hear and determine disputes between an employer and an employee. So before even Ken goes to court to challenge the decision of the employer, he has to ensure that he's going to the right court. And if you look at Article 162 of the Constitution, there's a hierarchy of courts. We have the High Court, we have the Environment and Land Court, we have the Employment and Labor Relations Court. So this being a dispute involving employment, he should make sure that he goes to the Employment and Labor Relations Court. So once he's lodged his claim, and even before the court comes to a determination on the remedies that the employee is entitled to, there's a lot of procedural aspects that the court will look into. Uh, One, the court will again look at, was there a contract of employment between the employer and the employee? They will look at how the procedure that was used to terminate the employee's contract. So let's say, for example, in the end, the court finds that the termination of Ken's employment was unfair, and against Section 45 of the Employment Act,
yes.
there are various remedies that can be given. So one, the court can issue an order for reinstatement.
Thank you, Counsel. I believe you have too much information to give us. I want you to hold on to your thoughts. I'm directing that we will take another short commercial break, but when law matters come back, we shall pick up from that point.
Okay.
Law matters come back shortly.
Msimu mpya, uso mpya, nguvu mpya, bila shaka na ari mpya, lakini dhamira ni ile ile: kuboresha kilimo kwa maisha bora. Jiunge nami James Baraka na nahodha wako mpya wa kipindi cha Boresha Kilimo, tunapochunguza mbinu za kisasa za kilimo, ukipenda teknolojia ibuka katika kilimo, maoni ya wataalamu na hadithi.
Welcome back to Law Matters, a show that will always put into context legal concepts in order to answer your questions, address your views and reviews through proper interviews. You can continue watching us and sending your questions and comments through Twitter, KUTV_Kenya, at Instagram, KUTV Kenya, and YouTube, KUTV Kenya. On our set, we have Counsel Otto Nuva and myself is Elvin Onsongo. Counsel.
Yes, Onsongo.
Under the laws that govern employment in Kenya, what are does our law talk about some grounds or reasons that do not amount or constitute fair grounds for termination?
Yes, the law talks about that in depth. There are reasons that explicitly do not amount to fair termination. They amount to unfair termination, and these are provided for by Section 46 of the Employment Act. And one of them is that dismissing an employee on account of his nationality, on account of his or her marital status, on account of his HIV status, ethnicity, that definitely amounts to unfair termination. Secondly, terminating the services of a pregnant lady while she's pregnant, that definitely amounts to unfair termination. And the courts have ruled that whenever an employer terminates the services of a lady who's pregnant, it's in violation of her rights. Another thing is terminating the services of an employee who is out for a lawful strike. So the employee has gone out for a strike which is lawful and which the employee is entitled to under Article 41 of the Constitution. If that contract is terminated, then that amounts to unfair termination. So those are some of the reasons that amount to unfair termination that can be impacted on an employee.
Probably for the benefits of our viewers as well, you can perhaps give us your take on what is the nexus between what you've told us on grounds that do not constitute fair grounds for termination vis-a-vis Article 27 of the Constitution that talks against discrimination. Do you see any sort of nexus or intermarriage between those two?
Yes, thank you for that question. There is definitely an intermarriage between Article 27 of the Constitution and Article 46 of the Employment Act. They basically prohibit discrimination of any form. And it is important to note that an employer in any way should not discriminate an employee for whichever reason. There cannot be a justifiable reason to discriminate an employee. So yes, there's definitely a nexus between the said provisions of the law.
Council, you'll allow me to ask you a question that comes from one of our viewers. His name is Gift. Goes by the name Gift Media, and he's saying, watching live from Nairobi CBD, and his question is, what are the key things one should look for in a work contract? Just in a nutshell to answer Gift Media.
Okay, thank you, Gift Media, for your question. So for a work contract, which is essentially a contract of service, there are very, very underlying provisions that you should uh, look into. One is the nature of the work which you're going to be engaged with. You have to be sure that you're getting into something which you can handle. Secondly, and this is also very important, you also have to look at the remuneration. Whenever you're discussing a contract of employment with your employee, ensure that the remuneration that you are getting is fair, and ensure that the working conditions which will be provided for will be reasonable. Another thing that you also have to look into is on the issuance of notices. Does the contract provide for a period when either the employer or employee can communicate to terminate the said employment contract? And additionally, this is also very, very important. Ensure that each and every clause in that employment contract, that you understand it, because there can be some provisions that can be put into the contract which might come to bother you in the coming
To
future.
haunt the parties in the contract.
Yes.
Council, you mentioned that an employee who is aggrieved by unfair termination of his or her contract goes to court for proper remedies. Now, what are these possible remedies the court can give during such litigation in court? And do we have a criteria in how or on how to calculate some of those remedies awarded by the courts?
So yes, we do. These are criteria, and there are things that the courts will look at. And for this to be in play, we are guided by sections 49 and section 50 of the Employment Act. So the remedies that are available to an employee who has been found to have been unfairly dismissed from work, one of them is reinstatement at work. But before now the court reinstates you back to work, they will look at the relationship that is existing between the employer and employee. Can it be repaired? Is it beyond repaired? Will they be in good working conditions once the employee goes back to work? And then you find that for some offices, public institutions which have been established by the Constitution, there's an easier it's easier for you to get reinstated to back to work, because that's an office that's been established by the Constitution and it's not a private entity. The next form of remedy is in terms of compensation. So what the Act provides is that you can receive a maximum of 12 months worth of your wages if you're found to have been unfairly dismissed. So for example, we have Ken here, and Ken is earning 30,000 shillings per month. And the court finds that Ken has been unfairly terminated from work. So the compensation, the maximum compensation that the courts can give is 12 months worth of wages. So it will be 12 months times 30,000. You get 360,000 as the maximum amount of compensation that can be given to Ken. The other one is on terminal dues. The court we look at was payment in lieu of notice given. So if the notice period was for 1 month, was Ken given his 30 months shillings, which is worth the amount of time he would have worked had he not been dismissed. If the notice period was 3 months, was Ken paid 90,000. The other remedy which is available is severance fees. So this applies to employees who have been declared redundant as a result of redundancy. So for the severance fee, it's calculated at 15 days worth pay multiplied by the number of years that you've worked. So the 15 days daily pay, so for this you'll do a calculation to establish how much Ken was earning on a daily basis. So if you're working with 30,000, we'll divide 30,000 divide by 30, we get 1,000. So per day Ken was earning 1,000 shillings. So he worked for 10 years. So how much is he entitled to? So it will be the 1,000 shillings times 15 times 10,000, and then this will bring you to 150,000. The other thing is Ken will also be entitled to payment for the unpaid leave days. If Ken's contract was terminated before he could go for his leave, he's entitled to payment for those days that have been left in his leave days. And lastly, Ken is also entitled to overtime. Ken proves to the court that he worked overtime outside the normal working hours. He worked, for example, during public holidays. He's entitled to that payment. Yes.
Thank you, Council. And perhaps finally you can tell us, after termination, after the end of contract of employment, is the employer obliged to issue any sorts of certificates to the now former employee? And as you answer that question, because I'm directed that we're running out of time, you can give us your closing remarks based on what we've had tonight.
Okay, thank you for your question. So pursuant to Section 51 of the Employment Act, the employee is entitled to be given a certificate of service. So the certificate of service is a document which will prove to everyone that the employee actually worked with the employer. And what will be contained in the certificate of service are the names of the employer, names of the employee, when the contract began, when the contract was dismissed, the form of business or engagements that the employee was involved in. And also it is important to note that once the certificate of service has been given to you, the employee is not obligated to give recommendations or to be your referee to your future employers. He's only entitled just to give you the certificate of service. And with that said, my last remarks will be the law is very interesting, and procedure is very important. It will save one a lot to know what is provided by the law. So ignorance cannot be an excuse to defend you if you've unfairly terminated the services of an employee. Yes. So with that said, it's been an honor being a guest today, and thank you so much, Nsonko.
Thank you, Council Otto Ndova. Council says the law is very interesting, and to our interesting viewers from wherever you are, thank you for being part of this show tonight, Law Matters. Till next week, same time, same day, take care of yourselves and continue watching KUTV. My name is Elvin.